Durk has filed a motion to sever counts or, in the alternative, to dismiss the TS1 on speedy trial grounds. The government proposes the following schedule. Motion filing date, June 26. Opposing motion date, July 6. Reply date due June 13, 2026. Hearing date, July 27. So we can see right here, you know what I'm saying, defendant banks to his counsel and all this stuff. Motion to sever or in the alternative to dismiss the third superseding indictment on speedy trial grounds as follows. So here you go right here. It says she's licensed in the state of Cali. She in good state, you know what I mean? I prepared a declaration in support of Mr. Banks' ex parte application for an order setting a briefing and hearing schedule on Mr. Banks' motion to sever or in the alternative to dismiss the third superseding indictment on speedy trial grounds. I have met and conferred with the government counsel regarding the briefing and hearing schedule on this motion. The government suggested the following schedule, which is agreeable to the defense. So we're going to turn it up on June 26th. You know what I'm saying? It's the motion filing date, which actually obviously is today. And then they're going to set their proposed motion. I mean, they're going to set their proposed opposition due date, July 6th, then proposed reply due date, July 13th, proposed hearing date, July 27th. You know what I'm saying? So there y'all go. But let's get on with this video. Imagine that you were a part of a crew. And imagine y'all did some BS where y'all essentially robbed a store in, let's say, California. Now, the person who alleged to have started the gang, he's done this before in Illinois, and he's done it before twice in Georgia. And you decide to say, yo, I'm being prosecuted for these other damn crimes by standing next to him, even though it's alleged that we done some of the same shit that has happened in two other states and in one state, two other cities. Well, that's the case that you have here with this new Lil Durk filing because two individuals are trying to get off the case, but I want to know, what do y'all think? Because this writing is very detailed, but I'm going to break it down the best way the hood lawyer can. So I got 3 readings for y'all. Enjoy. Hit that like button if you can and share this with a friend. I want to see what they cooked the hell up. United States District Court for the Central District of California, United States versus Durk Banks. Defendant Wilson's and defendant Lindsay's reply in support of renewed motion to sever. We're just going to get straight into it. The government's opposition rests on a single premise because each defendant is charged with vicar murder. The enterprise evidence is cross-admissible. So there can be no Rule 14 prejudice. That is not the law. Rule 14 asks whether, on this record, the jury can collate and appraise the individual evidence against each defendant. United States versus Fernandez. Proving that the enterprise committed murders is different from proving that the moving defendants did, and cross-admissibility to establish the enterprise elements does nothing to stop a jury from sliding from the first proposition to the second. If the enterprise label alone defeated Rule 14, no defendant charged under vicar could ever sever. The Ninth Circuit holds otherwise. Great disparity in the amounts of evidence introduced against joint defendants may, in rare cases, be grounds for severance. United States versus Patterson. This is that rare case. Mr. Wilson is charged in a single shooting, the August 2022 California murder of SR, and he is not alleged to have fired a shot. The jury that decides his guilt will also hear in full a murder in Illinois and 2 attempted murders in Georgia, none of which the indictment charges to Mr. Wilson or Mr. Lindsay. The conduct charged to the movements beyond the substantive offenses is not homicide. The violence the government will build around them is. Proof of that kind, untethered to the defendant who must sit through it, is the wholly desperate and disproportionate evidence Rule 14 reaches. United States versus Vasquez Valesio. The government leans on the court's prior severance denial as a dispositive here, but the court's reasoning points to other way now. The court tied that ruling to a record from which the Chicago murder had been withdrawn and called the motion considerably stronger with that evidence in the case. ECF 386 at 4. The third superseding indictment, TS1, has restored the Chicago murder and added the Atlanta attempted murder. The court never weighed on top of the Blackshear attempted murder, already admitted over objection, and now pleaded as an act of the enterprise. Now, the number one question that everybody's asking is this question. What's a Rule 14? A Rule 14 is basically fairness. It's like saying, yo, me being around all these cats and being charged with the same shit, that's cool, but you bringing in other shit about this person and this person when we all are only charged with this one thing, that makes the most sense. And when I get to the end of the video, you're going to understand why they should grant the severance, but ultimately they're not. Let's get on with the second part of this. Roll it. The prejudice the court assessed was a fraction of what the jury will now hear. A murder and 2 attempted murders, none charged to the movements while they defend a single shooting in Los Angeles. No instruction can close that gap. It asks jurors to do the impossible. Hear detailed proof of a murder and 2 attempted murders allegedly committed by others. Use that violence to understand the enterprise, but not let it bear on their judgment of the movements' guilt. That is the kind of mental gymnastics that is beyond not only their powers, but anybody else's. United States versus Gallo. The court must sever. Argument. The new indictment has not only restored the prejudice, the government withdrew but reversed the balance. The government's response to the changed posture is that the court's earlier reasoning was applicable to the prior indictment. That is why the renewed motion matters. Severance turns on the case as it now stands, not as it once did. A renewed motion allows the court to assess more accurately whether joinder is prejudicial once the evidence is fully developed. United States versus DeKalb. And the duty to sever continues throughout the case whenever prejudice appears. Schaefer versus United States. The government also invokes the court's observation that granting severance might have been an abuse of discretion the other way. True. The court made that statement under a different evidentiary landscape, where the Chicago murder had been withdrawn, ECF 386F4. It was addressing a single Los Angeles shooting, not the multi-state enterprise that TS1 now charges. A murder and 2 attempted murders the movements are not charged with committing. The government's position cannot be squared with the court's own prior view of this evidence. Before the government withdrew the Chicago murder, the court expressed its tentative view that this homicide was inadmissible under Rule 404B or Rule 403. ECF 380 had 2. Exclusion under Rule 403 rests on a determination that the evidence prejudice substantially outweighs its probative value. The TS1 does not lessen that prejudice because it no limited to Mr. Banks. The government answers that because the Chicago murder has now been pled as an act of the enterprise, it can be offered as direct evidence against all defendants. While the theory of admissibility may have changed, the prejudice stays the same. Indeed, now that the government has resurrected the Chicago murder as part of the new Vicar charge, the prejudice is far worse. Evidence the court was prepared to keep from the jury for all defendants is too prejudicial. Is now the evidence the jury must hear, developed in full because the government chose to charge the enterprise. The Atlanta attempted murder makes the point sharper still. The government never offered it as prior bad act evidence, so the court had no occasion to weigh its prejudice. The TS1 now pleads it as an act of the enterprise. The prior denial confronted nothing like this much violence, this much spillover, or this much risk of guilt by association. They already said, Judge, you heard the Chicago shit before, and you said it was unfair. Then they're going to add more shit onto it? So you already said it was tipping the balance. Nah, it's way the hell up here. So nah, Judge, that shit you said in the past, bruh, stand on that. And I'm going to be fair. They're making a hell of a point because if we have this big-ass enterprise, there has to be more to it. Don't worry, I'm going to get you exactly to where you need to be with this last one right here. Out-of-state violence as enterprise proof does not make it the movement's conduct, and cross-admissibility does not dissolve Rule 14. Contrary to the government's suggestion, Op 6, charging the movements under a racketeering enterprise does not make the enterprise's violence their own. The opposition lists the movements among those who engaged in acts of violence, including the Atlanta and Chicago killings. But the indictment attributes both to others. TS1, the statute keeps the two apart. Keep the two apart. To convict the movements of Vicar murder, the government must prove that the enterprise existed and engaged in racketeering activity, and that each defendant committed the charged violent crime for an enterprise purpose. United States versus Manning, but that's kind of what y'all doing right here. The Atlanta, Chicago, and Blackshear shootings committed by others bear on the enterprise. They are not proof of the movements committed the only violent act charged to them. The Los Angeles murder, cross-admissibility does not end the analysis. Even if all the enterprise evidence were admissible at a sever trial, a premise the movements need not accept, Rule 14 would still ask whether the jury can separate that proof as it relates to each defendant. At 8:45 through 46, the government treats admissibility as a dispositive, and never weighs whether the accumulation of this violence is unfairly prejudicial. A defendant with a discrete alleged role need not be forced to sit through the full presentation of an enterprise's violent history merely because some background proof overlaps. In Burke, the court severed a defendant from co-defendants charged with murders as racketeering predicates because although the government would present some overlapping proof concerning the movement's alleged status as background, the proof needed to convict him was substantially different from the proof needed to convict on the decades-long RICO conspiracy, United States versus Burke. The government will say the movements here, unlike the defendant, are charged with the enterprise crime itself, but that distinction changes only the label, not what the jury will hear. The enterprise element requires proof that the enterprise had racketeering character. Proving that the movements joined a single shooting does not require trying Atlanta, Chicago, and Blackshear in full. The danger is greatest when the spillover is violent. Relief by severance may be more appropriate when the unrelated evidence reflects activities of a violent nature because the risk of substantial prejudice is greater. I'm going to leave it right there. So it's like you being on a basketball team, right? And let's say one person broke a window. Another person stole from a store. Another person kicked the coach in the nuts. Another individual, all they do is goddamn get drunk and high and shit. You can't say because we all play for the same team that we're all guilty of the same shit. You're saying that this one murder that we did ties us to all of this shit over there. That ain't even fair. Because if it was truly about the enterprise and this is the shit y'all was waiting for, why aren't we charging more people? You got a shit ton of unindicted co-conspirators. Whoop-de-fucking-do. You need to put all that shit on the table. If you're going to say we're a big-ass gang, make some big-ass arresting. You need to go ahead and tie these individuals in there instead of saying, oh, well, there's this murder over here. Just think about the logic in that shit. Imagine about all the RICOs y'all heard, but this Vicar RICO, this new shit right here, nah, you don't get to bring in the two dudes who already killed these dudes, right? No. You don't get to bring in none of that shit. You don't get to bring in the alleged other shooters that were in Georgia for the other two shooters, well, because 3 of them are dead. But still, that shit is not gonna work. Then on top of that, where are y'all getting y'all information from? How do they know so much? Which one of them was doing all the shoot 'em up, bang, bang shit? You can't say we have a big-ass gang and this gang has so many members and we have so much money and we can fund people to fly and kill these people. Why didn't you just fly the same goddamn individuals from Chicago and Georgia all the way to, from Illinois and Georgia all the way to California? I shouldn't have had to recruit anybody because they were already ready. And that's where the government ultimately is losing their stupid ass battle because you're saying, oh, he recruited this person. He recruited that person. But it's all Banks Gang Enterprise. All right, well, if it's all Banks Gang Enterprise, are you saying that the Banks Gang Enterprise member took money from Lil Durk and gave it to these people? Because it goes directly against all of the shit you said before. So if Durk could pay these dudes in Chicago for getting the shit done, then why didn't he pay any of these other individuals? They don't have change. They don't have music songs. They don't have money. They don't have any of this shit. And then what about the shooters that's in Georgia? What the hell did they get? So only one set of people got paid? Because of one stupid ass post and somebody that's a part of some shit that got a chance to hang out? That makes him guilty of murder? Well, murder for hire, pardon me. I'm not seeing it. The issue that they're going to have is the feds are basically going to say, well, y'all still on the basketball team. It don't matter that you broke a damn glass window, you kicked the coach in the nuts, you get drunk and high, and this person does all this other shit. You're still on the basketball team, and we're proving that the basketball team is a bad basketball team, and that's all the feds are going to try to do. The judge should sever the case. Lil Durk ass got his shit going on to sever the case as well, but their standpoint is way better because they're right. I ain't accused of doing shit but this shit right here. Now, the government may come back and say, well, hold the hell on, bruh. You done did some foul, both of y'all done did some foul shit that we ain't even brought up. But since you want us to put it on the table, we gonna put it on the damn table. And they can do that shit. So we shall see, man. But will Durk get severance? No. I ain't even finna waste my time on explaining that shit. He ain't getting no severance, but it's worth the damn shot. But y'all, let me know y'all thoughts on this. I know I did a lot of talking, but hopefully my goal and how I'm doing my videos, because I don't believe anybody else is doing it like this. If they are, shout out to them. My goal is to help people understand all of this shit on a level that doesn't fly above our heads. Like I told you, if you've never heard this story before, I was in juvenile hall facing some little bullshit ass time for assault with a deadly weapon, 3 counts of assault and all this shit. And I remember feeling so goddamn stupid and dumb. That's what I felt. I felt like I had the freaking the education of an infant when I heard these lawyers talking and I didn't know what the hell they were saying. So I started to pick up a dictionary and started to read. And hopefully I've become at least not a dictionary, but more so a thesaurus for the rest of you. If I have, thank you. If I haven't, my attempt to get better and draw y'all in, I'm going to work at this every day. So if you don't mind, hit that subscribe button. If you don't, no shame, no harm, no foul. But hit that like button too if you rocking with us. And you already know, 10K away from these days giveaway. Remember we was at 90, 80, 70, 60, 50. It's getting there. We're finna get rid of this shit. And who knows? It might be a crazy giveaway. I might do something wild. But hey, we'll catch y'all in the next one. Click right here, though, to see how Hernandez Govan officially indicted on 2 counts facing 5 years in the feds. Click right here for that video or click right here for the playlist, and I will catch y'all in the next one.